My name is Lorena McElwain, and I am co-founder of SmartFeds Law Group. In this video, you will hear 5 things you need to know about how a federal shutdown impacts the EEO process if you are thinking about filing a complaint or if you have already started that process. The first thing you need to know is the Equal Employment Opportunity Commission, or EEOC, is the authority on regulations, policies, procedures, and timelines associated with the complaint process. An executive agency that falls under the EEOC cannot on its own have procedures or timelines that contradict those in the EEOC regulations. For example, the EEOC specifies the timeline associated with each step of the EEO process, and in recent years, the EEOC has not paused or waived the timelines in response to a shutdown. So the first timeline you need to be aware of is if you believe you have been a victim of discrimination, you have 45 days. Those are calendar days from the date the incident occurred or when you learned of the incident to contact the EEO office or EEO counselor. Reaching out to the EEO office does not compel you to file a formal complaint, but it is the best way to preserve your right to file a complaint in the future. And if you do file a complaint and change your mind down the line, you can always withdraw the matter at any point in time before a third party makes a decision on your case. During a shutdown, there is nobody to answer mail, calls, or emails. However, the burden is still on the aggrieved person to make a reasonable effort to contact the EEO office or the EEO counselor. To make sure you are timely during a shutdown, the best thing to do is to either mail a certified letter to the EEO office and keep the delivery confirmation as evidence, or email the EEO office from your personal email and copy yourself. Of course, you will not hear from them until the shutdown ends, but you'll be able to preserve your right to file a formal complaint if you are on record as having made an effort to timely contact the office. The second thing you need to know is agencies do not have the flexibility to waive the 45-day timeline. In fact, the EEOC regulations state an agency must dismiss a formal complaint for untimeliness. If an agency inappropriately accepts your untimely complaint, they risk getting sanctioned. The third thing you need to know is making the argument you were unaware of the 45-day timeline is rarely a winning strategy. This is because the agency will likely argue that you knew or should have known about this timeline. To name some common examples, agencies do this by showing they conveyed the 45-day requirement during new employee orientation, through physical posters in common areas, through annual EEO policy statements broadcast to the entire workforce, through website postings, and communicated during mandatory annual EEO training, which if you took, then you knew, and if you didn't take, then that's on you, and you should have known. In essence, it is very difficult to claim you did not know about the 45-day timeline. The fourth thing you need to know is related to formal complaints. Let's say you went through the counseling phase and the agency issued you a notice of right to file stating you have 15 calendar days from the notice to file a formal complaint. During a shutdown, make sure you file via certified mail or via email to keep proof of when you filed. If you are untimely, your matter will most likely be dismissed at the agency or EEOC level. The fifth thing you need to know is if you filed a timely complaint and the agency accepted it for investigation, the agency has 180 days from the date you filed to investigate it and issue you a report of investigation. The regulations state that if the agency misses the 180-day timeframe, they need to notify you in writing of when they expect to have this report to you, and that because they have missed their timeline, you now have the right to bypass the administrative grievance process and file a discrimination lawsuit in federal district court against the federal government. You can also file a motion with the EEOC to sanction the agency for untimeliness. Remember, the clock doesn't stop for anyone just because of a shutdown. If you are unsure whether your issue is an EEO matter, check out our video describing potential administrative venues available to federal employees and our video describing the elements of an EEO claim. SmartFeds offers our signature EEO Smarts coaching to employees, supervisors, and union stewards on how to engage in the complaint or administrative grievance process, understanding which options may be available to you, whether you should hire an attorney, responding to affidavits, and witness preparation to testify before a third party. Visit our website, smartfeds.net, to schedule a consultation or to sign up for our monthly webinar where you can ask anything EEO related. If you found this information useful, subscribe to our channel, like this video, and share it with others. Stay smart, stay strong.